Now agreeing to go live.
All right.
Just for a second, and I'll tell Sonali. And we're there. Sonali, thank you.
Bob Schwartz co-founded the Juvenile Law Center in 1975, an organization dedicated to fighting for rights, dignity, equity, and opportunity for youth. It is the first nonprofit public interest law firm for children in this country and ultimately aims to abolish carceral systems so that all young people can thrive. Professor Schwartz served as executive director of the Juvenile Law Center from 1982 to 2015, after which he became a visiting fellow at the Stoneleaf Foundation. In 2016, Professor Schwartz joined the National Association of Counsel for Children, and the following year accepted the position of Beck Chair in Law at Temple University's Beasley School of Law. He is currently a visiting scholar at the law school. As part of his work at the Juvenile Law Center, Professor Schwartz represented children in PA juvenile and appellate courts. He initiated class action litigation over the conditions of youth facilities and the functions of probation. He has also testified before congressional committees and addressed communities in more than 30 states about how children are impacted by harmful laws in our carceral system. Professor Schwartz has also served as a member of the MacArthur Foundation Research Network on Adolescent Development and Juvenile Justice, as well as an appointee to the Pennsylvania Commission on Crime and Delinquency. Professor Schwartz's career transcends his litigation in PA courts. As chair of the American Bar Association's Commission on Youth at Risk, the Juvenile Justice Committee of the American Bar Association's Criminal Justice Section, and the Advisory Committee to the Children's Rights Division of Human Rights Watch, he has taken his fight for children's rights to a national level. Professor Schwartz has also spoken up for children's rights overseas. In 1993, he helped to develop a legal system for children in South Africa, and in 2010, he spoke to judges and lawyers about youth sentencing in China. Professor Schwartz earned his BA from Haverford College in Sociology and Philosophy and received a JD from Temple University's Beasley School of Law. His work exemplifies the type of Philly and PA-based advocacy that ABCS courses like ours seek to amplify. 40 years after founding the Juvenile Law Center, he's been instrumental in changing the way American law defines childhood. Learning about his longstanding involvement in juvenile justice and efforts to abolish the carceral state, particularly in regard to young people, will be deeply insightful for our own efforts to promote the youth vote. The talk today will help us to understand the multifaceted nature of obstacles that young people in our city face in practicing civic engagement and navigating our democracy. Thank you so much for joining our class today.
Thank you so much for your very generous introduction. That means a lot to me. I will be talking this evening about sort of legislation and the importance of voting, but I'm going to be doing that indirectly by describing the campaign to end the juvenile death penalty in the United States and how state legislation was important to that effort. And I'm going to begin with the story of George Stinney, who was 14 years old, living in a small town in South Carolina in 1944, when he was arrested for the murder of two younger white girls who lived on the other side of town. He was an African-American boy, and they were found in the African-American side of town. George was arrested, although he'd been with his sister the night of the murder. His trial shortly after his arrest lasted 2.5 hours. He had a court-appointed attorney who was running for county assessor who introduced no witnesses and questioned none. The jury took 10 minutes to come back with a verdict of death. There's a movie about the case, a recent movie called 83 Days that you might want to see. It was 83 days from George's arrest to his execution in the electric chair. He was under 5 feet tall and he weighed less than 100 pounds. He was too small for the chair. So he was boosted by books that he had to sit on, and straps had to be retrofitted to get around his arms. It took 10 minutes to convict, 4 minutes to execute him. It was 70 years before he was exonerated with a new trial in 2014. That was not atypical in the first half of the 20th century, but it wasn't until the late 1980s that the United States Supreme Court got around to addressing whether executing children like George Stinney was unconstitutional. These cases and the one that ended the death penalty years later show the importance of state law and of voting for people who pass those laws. The Eighth Amendment is relatively brief. I always go back to my Constitution, which is, you should all have a copy at hand. It's one sentence: excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Does executing someone who was under 18 at the time of the crime violate the Eighth Amendment? Is it cruel and unusual? Two late 1980s Supreme Court cases, both involving brutal murders, tried to answer that question. And unlike the case of George Stinney, there wasn't a question of whether or not the boys involved had actually committed the crimes. The question with those under the age of 18 was whether their age was just one more mitigating factor that should be addressed at sentencing. The court had set up an elaborate capital punishment scheme of aggravating circumstances and mitigating circumstances. Age was on the mitigating side for many people. For some prosecutors, it was an aggravator, because look how dangerous this child is already at the age of 15, 16, or 17. The question for the court was, should it stay as a just one factor, however it was decided, or is it age the kind of factor that would make executing a minor so disproportional to their blameworthiness that the Supreme Court should draw a bright line? Most areas of the law involving age involve bright lines. We don't let those under 18 vote, even though many under 18 are wise enough to vote, and many over 18 are not. We draw a line as for lots of societal reasons. We don't let those under 18 enter into binding contracts. The question for the Supreme Court in the late 1980s was whether the Eighth Amendment's ban on cruel and unusual punishment required a bright line to be drawn, or whether the death penalty was sometimes permissible for those like George Stinney who were minors. The first case was Thompson versus Oklahoma. William Wayne Thompson was 15 and involved with 3 adults in the murder of his former brother-in-law. He was tried as an adult, so he was subject to adult penalties. He was sentenced to death. Right? He was 15. Was the death penalty cruel and unusual punishment for him? You have all probably followed the debate over how the Supreme Court interprets cases. There's the new wave of originalists who look to the original meaning in the Constitution. But even the originalists didn't want to go back to what was happening in 1789, because 200 years earlier, at the time the Constitution and the Bill of Rights was adopted, it was permissible to execute anyone who was 14 or 15 or 16 or 17. In other contexts, people were stoned to death. Cruel and unusual punishment had a different meaning in those days. The court today has adopted a different standard. It considers, when determining whether something is cruel and unusual, the evolving standards of decency that mark the progress of a maturing society. That's the evolving standards of decency that mark the progress of a maturing society. Excuse me. So how do you decide what's cruel and unusual? How do you determine the evolving standards of decency? One way, used differently, but used by both liberals and conservatives on the court, is to look at what state legislatures do. look at state law. This helps the court decide whether the penalty is unusual as well as cruel. The court in Thompson, this was now 1988, found that the death penalty was unconstitutional, but only for those under 16. They didn't address 16 and 17-year-olds. The justices looked at several factors. First, every state's juvenile justice system included minors at least up to age 16. There were a lot of states that treated 17-year-olds as adults automatically. There were a lot, or several at the time, who treated 16-year-olds as adults. New York and North Carolina, for example. Those have changed their laws recently. But nobody had a juvenile justice system that excluded anybody younger than 15, 14, 13, you were considered a juvenile unless you were tried as an adult, and there's a whole system of deciding that, especially in cases of murder. State legislation in other areas, such as voting and serving on juries, all set bright lines, at least at 18. When it came to the death penalty at the time, 14 states banned it entirely, banned the death penalty for everyone. 18 states set the minimum age for execution at 16. Thus, in the eyes of the justices who ruled in Thompson, 32 states would prohibit the execution of those under 16. The dissenters didn't want to count those who banned the death penalty for everyone, saying they didn't look at age. So we shouldn't say whether there's a national consensus, but that idea was rejected by the majority in Thompson. In addition, juries after the 1940s did not sentence anyone under 16 to death. So in addition to state law, state practice showed that this was an unusual practice and was unusual enough to be cruel and unusual. So executing people under 16 was banned. A year later, Stanford versus Kentucky went the other way. Kevin Stanford was 17 years old and 4 months when he was involved in another brutal murder. Now 5 justices, the conservative wing of the court, decided that evolving standards of decency did not prohibit individualized consideration by juries, that it permitted the execution of 16 and 17-year-olds. Justice Scalia, speaking for the conservative justices, said that the validity of retribution or deterrence, which had been rejected in Thompson as justifications for the death penalty, wasn't for the court to decide, but for state legislatures, to which the court owed deference. Only 15 states barred execution of 16-year-olds at the time, and only 12 barred execution of 17-year-olds. As I mentioned, Scalia refused to look at the states that barred the death penalty entirely. So he decided, and his 4 other colleagues did, that there was no national consensus when you look at state laws. And the fact that juries rarely sentenced 16 and 17-year-olds to death meant to them that the system worked, that juries made individual determinations and only sentenced the most deserving to death in the eyes of those justices. Thus, executing 16 and 17-year-olds did not violate the 8th Amendment. That's where we were in 1989. 2 other things happened in 1989 that I'll mention briefly. One was that the Supreme Court held that it was permissible to execute people who were adults who were identified as mentally retarded, people who we now call people with intellectual disabilities. Second, the international community adopted a Convention on the Rights of the Child. The UN adopted it. Today, the United States is the only country in the world that has not ratified it. One of its articles bans the execution of those under the age of 18. That was the international view in 1989. In the years right after that, it was not a very good time for justice for children. Crime had gone up, juvenile crime had gone up. Scholars were calling kids super predators and predicting a new wave of violent juvenile crime, a wave that never happened, actually, as demographics is not destiny. State laws did change, though. I lost many battles in the early 90s as states changed their laws to try more and more children as adults and put them in harsher and harsher circumstances. it was not a good time. In 1995, the MacArthur Foundation Research Network on Adolescent Development and Juvenile Justice was created. I was a member of that research network, which was chaired by Professor Lorene Steinberg of Temple University, a developmental psychologist. The research network brought together scholars and practitioners. I think the practitioners were, like me, were around to help keep the scholars focused on what was important rather than what was interesting in their work. And they did serious research. We did serious research, although I was a tail on a very large research animal, looking at issues tied to teenagers and how they behave and how that behavior was relevant to the criminal law. By 2000, the research was substantial that teens as a class were different from adults as a class in numerous significant ways that had relevance for the justice system. Taking that research, about 20 of us convened in 2000 at Northwestern Law School in Chicago to plan a campaign that would build on the MacArthur Research Network and seek to overturn the 1989 Stanford decision. We wanted to end the juvenile death penalty. So we developed a multifaceted plan. And one thing I would say here that I've said to anybody who has listened to me is that one strategy never works. You have to try everything, as you just don't know what will create options for success along the way. So we had a plan that would develop international opinion focused on the US practice of executing minors. We worked with the religious community, national religious organizations, to develop their momentum in opposition to the juvenile death penalty. We went to professional organizations like the American Psychological and Psychiatric Associations, American Academy of Pediatrics and Adolescent Medicine, to get them supporting resolutions against the juvenile death penalty, the American Bar Association and other bar associations. We worked with attorneys around the country when they had cases, bad cases, but where death was a possibility for their 16 or 17-year-old clients. We had a communication strategy. And most importantly, since the Supreme Court counted state laws, we were determined to try to get more state legislatures banning the execution of minors. We pulled all of that together and lots of people were involved. I had, by the time this got going, a relatively minor role. Juvenile Law Center was a big player. We had lots of staff working on this. I thought that the campaign would take 20 years to succeed. It took 5. We were helped in 2002, again, by the US Supreme Court, when it reversed the 1989 decision around mental retardation. In Atkins versus Virginia, the court said that it was unconstitutional to execute those with intellectual disabilities. And again, this was based on counting state laws. Because in 1989, only 2 states had explicitly banned the execution of those with mental retardation, as it was then called. Since then, many more states had changed their laws, and the trend was unmistakable. The Supreme Court in Atkins therefore found a national consensus that those with intellectual disabilities weren't blameworthy enough to warrant execution. The court drew a bright line. They weren't going to allow for individual determinations anymore about whether this person who was intellectually disabled was blameworthy enough. It was none with intellectual disabilities were eligible for death. Executing them would violate the 8th Amendment's proscription on cruel and unusual punishment. So that was an opportunity. That was a door that opened for us that none of us had expected, especially when the next year, the Missouri Supreme Court relied on Atkins, that intellectual disabilities case, and said that 16 and 17-year-olds were in a similar position. That research that the MacArthur Network had done and other research related to it showed that those youth, 16 and 17-year-olds, were less blameworthy, that they were like adults with intellectual disabilities. Missouri, in a way, was throwing a challenge to the Supreme Court of the United States by disregarding its 1989 decision. It could have decided the case under Missouri's constitution, but it chose not to in order to force the US Supreme Court to rule in a different way. The US Supreme Court accepted the challenge, and in 2005, in a case called Roper versus Simmons, 5 justices agreed with the Missouri court that executing anyone under 18 was now unconstitutional. Christopher Simmons was 17 when he committed a horrific murder and bragged about it. He was involved in a home burglary, murder of a woman in a brutal way, throwing her body over a bridge. None of these cases are ever good. You never have facts that are helpful in death penalty cases unless you could show innocence or lesser involvement. But Simmons was sentenced to death, and it was that sentence that the Missouri Supreme Court overturned. The US Supreme Court had to decide whether Missouri had correctly interpreted the Eighth Amendment and had to revisit Stanford versus Kentucky. At the time, in the United States, there were 72 kids on death row. The majority first looked to state law and then took its own turn at exercising independent judgment at what it meant for the evolving practices in this country involving standards of decency in a maturing society. 18 states had now banned execution of those under 18. Our campaign to change state laws hadn't been overwhelmingly successful, but we got enough new states to ban execution of 16 and 17-year-olds to show a trend. Those 18 plus those that banned the death penalty altogether, in the eyes of the majority, created a national consensus. In addition, since Stanford in 1989, only 6 states had executed anyone under 18. And since 1995, only 3 states had: Oklahoma, Texas, and Virginia. Standards of decency had indeed evolved. Execution of 16 and 17-year-olds was unusual. To use its independent judgment, the court looked at the work of the leaders of the MacArthur Research Network, Professor Steinberg and Professor Elizabeth Scott, who's at Columbia University Law School, both of whom at one time or another have been board members of Juvenile Law Center, had written an article called "Less Guilty by Reason of Adolescence," trying to show how the teenage brain worked in a way that made them less culpable. Not guilty, just less guilty. There were 3 factors, and the Supreme Court in Christopher Simmons' case adopted those 3 in a way that has since been very significant for the law involving kids. One was kids' lack of maturity. Teenagers are risk takers. They don't foresee risks. They underestimate the severity of risks. They're more likely to take risks. That distinguishes them from adults. Second, kids respond to peer pressure in ways that adults do not. If you take a look at the data on kid crime, most of it is done in groups. Teenagers rarely act alone. Peer pressure distinguishes them, and that's in part a feature of adolescence. And as we'd learned later on, it's a feature of the brain itself. Third, teenage character is not as well formed as that of adults. We can't tell who this person will become. I mean, for any of you who have seen The Shawshank Redemption, you know that Red, Morgan Freeman's character, is a different character at the end of the movie than he was, as he himself says, as a 15-year-old, too stupid to control what he was doing. Character changes, and the death penalty eliminates any chance of knowing whose character will change and whose will not. So the court drew a line. They also said that retribution, the eye for an eye view, and deterrence don't apply to kids. First of all, retribution doesn't apply when they're less guilty. This sort of eye for an eye doesn't work. And a punishment of teenagers who behave rashly doesn't deter others who also behave rashly. It just doesn't make sense. So they drew a bright line and held the death penalty for 16 and 17-year-olds unconstitutional 5 years after our campaign began. In addition, Justice Kennedy, who summered in Europe studying international law, took the time to note that this brought the United States into line with the rest of the world. He discussed the Convention on the Rights of the Child, which had been adopted in 1989, and he also made note of the brief of the bar associations of England and Wales, which we had brought in. We had brought those bar associations into our orbit, working on the case. The Simmons case turned out to be about much more than the death penalty. Because it was based on adolescent development as much as on the death penalty, it gave us an opportunity to work afterwards on state legislation in many other areas of the justice system to try to get states to make laws less punitive and provide more opportunities for kids to turn their lives around. So it's in state capitals that much of the work is being done to roll back the get tough legislation of the early 90s. I didn't know in 2005 whether Roper v. Simmons was a case about death or whether it was a case about kids. It turned out to be a case about kids, and that has transformed legislation in lots of areas, not only from the justice system, but to foster care, to other exercise of kids' rights along the way. After Roper, and right around that time, neuroscience, the functional magnetic resonance imaging of the brain has expanded enormously and has affirmed and deepened the developmental psychology research. Later Supreme Court cases ending mandatory life without parole for kids and deciding other cases around the validity of kids' confessions relied on the developmental work and the neuroscience work as well. So the campaign that began in 2000 to change state laws in one area succeeded not only in ending it 5 years later, but in giving us opportunities in state legislatures around the country on so many other issues as well. Who we elect to state legislatures matters because the Supreme Court listens to those legislatures. The Roper case and subsequent research have opened up endless possibilities for reformers to change state laws. That's a topic for a different discussion, but I think it's illustrative of what we want to discuss as a group now as we go forward. So I will leave it there, Professor Cary, and take questions.
Thank you. Wow, thank you. I'm going to ask everyone to reinstate your videos. There is so much to learn there for us. So much to learn. I'm going to ask, we have a few students who are actually thinking of law school. So I'm going to start with them to ask them what are their, what questions they have after listening to you. Yeah, please, Bars. Angela.
Hi. First off, thank you for coming to speak with us today. So I guess I thought it was really interesting how you brought up at the start how, kids under the age of 18 aren't allowed to vote yet. For a while, it was kind of debated whether or not the death penalty should be applied to them, if it was constitutional, or if it was cruel and unusual punishment. And you kind of mentioned how, in terms of the campaign against the death penalty for kids younger than 18, people brought up how kids can be easily influenced by their peers. I think you mentioned one of the quotes about how kids are too stupid to know what they're doing. So I guess going back to what our class is focused on, we're very heavily focused on voting for getting younger kids more interested in voting. How do you kind of balance this idea of these defenses of why kids shouldn't be applied the death penalty, which I completely agree with. With the other, I guess the other side of the argument, or not the argument, the other side is that we're advocating for younger kids to also be able to vote. I don't know if that makes sense. I was
No, it
trying
does.
to.
No, it makes absolute sense, and it's a great question. And so let me just reframe that too stupid comment, which I didn't quite mean that way, because
Right, no.
it's distinguishing between what happens on the street during times of conflict and crisis versus what happens when people are thinking clearly and calmly. Is what neurologists call the distinction between hot cognition and cold cognition. Hot cognition happens in a fight on the street, and the wiring of the brain operates. And in that situation, cognition for kids is very different than that of adults. That's not true in the research of the adolescent brain and adolescent development in times of cold cognition. So it's, in fact, by the time you're 16, kids' cognition is basically the same as that of adults in the lab, in the classroom, in many ways of life. So I would say go for it. That you need to be able to make distinctions, and the law needs to be able to make distinctions between the circumstances in which people make choices. And the punitive system that punishes people, say with execution or life without parole, for bad choices in bad times is just a different legal framework than whether or not people who are making rational decisions in calm times, how they should be treated. So I think you have ammunition, if that answer helps.
Yeah, definitely. I want to make it clear that I didn't necessarily think that the two arguments applied to both debates. I guess my question was more about, for legislators who might misunderstand, how people characterize children in one way or young adults in one way versus the other, and using those arguments against,
Well, this comes up all the time right now because legislatures like to accuse us of hypocrisy. And say you want more rights for kids under the age of 18, but you don't want them to be executed or sentenced to long adult sentences. But the fact is that kids' capacities to make choices depend on the choice that's being made. And every context is different. This is a big deal, by the way, in the reproductive rights area. In the 80s, the ACLU could not take a position on the juvenile death penalty because its reproductive rights division didn't want a statement to appear to mean that young women couldn't make a decision about whether to end their pregnancy or not. But the capacity to make that decision is different than the qualities that are involved in committing a crime under different circumstances. And that's true of almost anything. We had in our brief, though, Juvenile Law Center organized the sort of national nonprofit child advocacy brief. There were 16 briefs filed in Roper v. Simmons that was decided in 2005. And we had an appendix that listed all the ways in line drawing treated kids, so it's more than just the vote. I mean, it's whether you could get your nose pierced, whether you could go to a tanning parlor, there with smoke, drink. I mean, there are a zillion things where lines are drawn, even though many kids are quite capable of making those decisions. So it's figuring out the issue you're working on and making the argument that adolescent capacities are adequate to the task at hand. And there's a lot of research that could support that view.
Great, thank you.
Great. Yes, I have Mr. Lynn and Ms. Paulding. And then
Sure.
Ms. Hairston, I see. Okay, we'll move along.
First, I want to thank you, obviously, for taking the time to speak with us.
You're very welcome.
Is my connection a little bit off right now?
No, you're okay.
Okay, great. I wanted to ask you this. You mentioned that you originally thought your campaign was going to take somewhere around 20 years, but in actuality, it took 5. I wanted to ask you what you thought was the most salient part of your campaign in bringing about that change.
Uh, that's also a great question. I thought it was 20 because I was looking backwards, not forward. And if any of you have had the opportunity to read Richard Kluger's masterpiece, a book called Simple Justice, it describes the 20-year campaign that led to Brown versus Board of Education being decided, that it was a very gradual, step-by-step and strategic vehicle for Thurgood Marshall and his colleagues, that in those days, which was pre-internet, pre-email, everything took longer, communications was different, changing public opinion was different. 20 years was about the time it took for a national campaign. Our ability to reach people around the world was far easier than I ever expected in 2000. I mean, I myself am more of like a fairly retro 19th century mentality, so it took me a while to catch up with what was going on this century. And so electronic media, communication strategies, the ability to get research out quickly into lay people's hands. There was a lot going on very, very rapidly. The catalyst, though, at the end of the day, was the Missouri Supreme Court. It was just I think what happened was that the Chief Justice of the Missouri Supreme Court was ticked off that the Senate in the last years of the Clinton administration, I think, refused to confirm him or think about him, for the U.S. Supreme Court, and wanted to send a message. So there was intercourt politics that we didn't anticipate, and it was up yours. And that was, you can't predict that kind of thing, when you're doing a campaign. As I said, you have to do everything. So it's a great question, and I think that you don't know. It's, if I could use a sports analogy that I've used, because a close friend of mine in the 80s was Penn's football coach, and he once told me that maybe 3 plays in a game out of the 100 that the team runs will really make a difference. Only you don't know in advance which 3 are going to make a difference. You have to try so many different things in the hope that you'll have a breakthrough somewhere. You can't predict where that's going to happen. And we couldn't predict Missouri, let alone that we'd have international support as quickly as we did. So that's a long answer to a short but very good question. Thank you. Ms. Paulding?
Hi, I also wanted to thank you for speaking. I'm from England, so I thought this was really interesting because I didn't even realize that you could be given the death penalty. But my question was actually about what your opinion was on fining and trialing the parents in a situation like this, because I know at the moment there's what is it? It's the Oxford mass shooters' parents are on trial for like their involvement in like kind of their responsibility as a parent. And I just thought like whether you had an opinion or like what your thoughts were on like a parent's involvement in their child's crime, like just from like a parenting stance.
Right.
I don't know
sure. No, I get it. That's another terrific question. And I'll be in London next week, meeting with colleagues, on who are catching up with us on race equity issues, and how to tackle them in the UK. But the issue of parental responsibility comes up now and then. And by and large, we don't hold surrogates responsible for other people's crimes. So if parents are sort of involved, let's say, in giving a car to an underage minor who doesn't have a license, or to a kid who is drunk or is holding a party, and is responsible in at least a dotted line way, there's an argument for finding some degree of responsibility. And the law is very nuanced on that. But by and large, we ought not, and we don't, and I don't think we should hold parents responsible for their children's conduct in that way, in the criminal law. It's bad enough the way we treat parents in the neglect and abuse area right now, in breaking up families, often quite unnecessarily, without providing support. There are just too many instances where kids are on their own, parents are working, parents are occupied with other children. A lot of this crime happens after school, when kids are getting together to figure out what mischief they can engage in, so the parental responsibility for me has been a non-starter, although there have been states that have tried to fine parents for the conduct of their kids, and that doesn't work well at all. It's unclear what purpose that will achieve. I mean, if indeed one is trying to deter certain kinds of behavior, or there are a number of other purposes of the criminal laws of incapacitation, to get people out of circulation. There's retribution, there's rehabilitation, and there's two kinds of deterrence of this individual who committed the crime and the public in general. It's unclear to me what kind of conduct would be addressed by the criminal law in a way that would either deter or be retributive in an appropriate way. So I don't like the idea as a rule. I think parents should be involved in supporting their kids after the fact and in helping turn them around. And we can help parents with children's reentry from juvenile placements when that happens far too often in this country. But reentry and aftercare has been a part of a national movement since probably about a dozen years ago, when Congress passed the Second Chances Act. So, but parents should be involved in second chances, but I wouldn't hold them accountable that way. So there's a question in the chat room from, were there any demographic changes? So the question is about racial disparities. As in sort of all aspects of the criminal law, there are, the punishment was applied disproportionately to African-American youth. Gender, there are almost, I mean, it certainly is all class disparities. I mean, yes, for sure. Rich people, by and large, don't get executed. It just doesn't happen. The lawyering, for kids in these cases has been terrible, which is why our campaign tried to improve lawyering for kids along the way. Girls are never sentenced to death, just doesn't happen. Again, probably for gender stereotypes that works in their favor, in this one instance. But it's that they're not as bad as, it works that way. The first executions, are almost always of white people before you get the array of executions of Blacks in the United States. And that's, I think, to give the impression that this is a race-neutral system when all the data show that it's not. There was a study that the Supreme Court rejected many years ago that showed how the disparities play out. And it's actually not that much about the race of the offender as much as about the race of the victim. So when white people are killed, death penalty skyrocketed for Black defendants. And the Supreme Court said we can't look at data, we have to look at whether there's discrimination and bias in this individual case, which is very hard to prove. The data was overwhelming. And we actually thought we could end the death penalty on that alone. But a very conservative court in the 80s went the other way. So there are disparities on class, there are disparities on race, less so on gender or on gender identity. Because actually, frankly, the death penalty right now is increasingly rare, and I think is on its way out for everyone. Yes.
Thank you, Mr. Schwartz, for coming to speak with us, as everybody else said. But what are some of your current projects now that the child death penalty has been banned?
Well, I'm retired, so I don't have current projects, but Juvenile Law Center does and is working on, for example, mandatory sentencing laws that sentenced when kids were tried as adults, they received the same mandatory sentences that adults got. Human Rights Watch, through its California office, got California to change its sentencing laws and working on getting rid of mandatory minimums for kids who were tried as adults is a big project. Eliminating fees and fines that stay with kids through their lives is another big deal. And you may not know, but that kids are often charged for their presence in juvenile court. They're charged for probation supervision. They could be charged for just the cost of the court proceedings. And while they're supposed to figure out ability to pay, the fines are often enormous and far beyond kids' ability to pay. Those get translated into judgments that follow the kids and undermine adult paychecks as fines are then withdrawn later on. So that there are many ways that kids' opportunities to succeed are impeded by a system that was, in theory, designed to help the juvenile court system itself. The whole idea of trying kids as adults is one that we're still working on. I say we, Juvenile Law Center is still working on. And to roll back many of the mid-90s reforms in which kids were automatically tried as adults, in which kids were automatically sent by prosecutors, not judges, to the adult system willy-nilly. So that was a big deal at that end. And then there's also the work of setting a minimum age, which is now, I think, on the national radar screen. So, and this is coming up in the UK and other places as well, is if you, there's no lower age limit in Pennsylvania for murder. So we were involved, again, I'm looking back at the late 80s, in the case of a 9-year-old boy who was tried as an adult after being disciplined for not cleaning up his dishes when playing Nintendo with his 7-year-old neighbor. She went out on a snowmobile. He shot his father's rifle out the window and killed her. He was tried as an adult. His Miranda warnings were given while he sat on his parents' laps with his Garfield sweatshirt on. The judge found that he should be tried as an adult because when first asked about it, he lied. And that's what adults do. Adults lie. This boy lied. Therefore, he's an adult. Those of you who have studied logic can pierce that one. He also showed no remorse because in the endless hours and hours of pretrial hearings, he would fall asleep at counsel table, showing that he just didn't care in the eyes of the court. It took us 4 years to get that case sent back to juvenile court. But that's an example in Pennsylvania. If you're 10, you could be tried in juvenile court here. In New York, it was 7 or 8. You could be tried in juvenile court. Around the country, the ages differ. But getting a developmental perspective that brings the law into alignment with developmental science is a big part of the work of what children's lawyers are doing right now. So it's not, in the 1980s, it was a bumper sticker that drove policy. It was adult time for adult crime. Now, legislators know this isn't adult crime, it's kid crime, and the law should respond accordingly.
Thank you.
You're very welcome. I don't see other hands, Professor Cary.
I don't see other hands either. Sometimes people take a moment. There's so much. I mean, this is so rich, and there's so many issues. Yeah, it takes a minute.
Yes, Ms. Downs. Yes.
Hi,
Hi
thank
there.
you for speaking. I have a question about trying a minor's as an adult. Is that typically decided on a situational basis, or is there like a list of criteria that needs to be met?
Great question. It used to be both. In 1966, the Supreme Court decided a case out of Washington, D.C., that basically said you have to look at the factors that are listed in the D.C. statute, the degree of involvement in the crime, prior history, age, blah, blah, blah. There were about 8 factors involved. And most states adopted a model code in the early 70s that followed that Supreme Court case. And the prosecution had to show a judge that A, it was more likely than not that this kid committed the crime, and second, that those factors were in place so that it was unlikely that the juvenile justice system could manage the risk to the public and rehabilitate this kid. So we had what we call judicial waiver. That all changed in the early 90s with the super predator fear and the rising juvenile crime rate. So in Pennsylvania, for example, it became automatic to try kids in adult court, not only for murder, which had already been an automatic bright line adult offense, as you could see by that 9-year-old being tried as an adult, but also for any one of 7 felonies committed with a weapon. Now, a weapon turned out to be a baseball bat, as well as a gun. And so prosecutors would make the charge. These kids would start in the adult system. There were many states had what they call prosecutorial discretion. The prosecutor could decide where the kid went. Outrageous policy that gave enormous power to district attorneys who would often use that leverage to get a plea bargain out of kids who didn't know better. So there was a mix of some states like Illinois created an automatic trial of kids as adults if they sold drugs within 1,000 feet of a school. Now, in Cook County, where Chicago is, that turned out to involve everywhere. So there was, and given the disproportionate number of African-American and Latino kids in Cook County, the kids who were automatically tried as adults in Illinois for that crime all came out of Chicago. It was what I called a game of chutes and ladders. If any of you, I may be dating myself there too, but where the ladders got kids in a variety of ways to the adult system, but Illinois provided no chutes. Some of the success was in the years around that time was to getting a way to get kids back. Now what we're doing, and this goes to an earlier question as well, is trying to get those laws repealed entirely and go back to judicial discretion. There has to be some evidence and a legitimate hearing that the juvenile justice system cannot manage the risk, because this system can hold kids up until age 21. So we were involved with was it a 10-year-old? Was it 10? She 10 or 12, who was tried as an adult in Philadelphia 20 years ago. Really emotionally disturbed, intellectually disabled young girl who wanted to go back into foster care after being sent home and stabbed the first person she saw on the street, killing her. It was a horrible crime, but the judge decided that the juvenile system, in the either 9 or 12 years available to it, was unlikely to turn her around. Therefore, she needed to be tried as an adult. I thought that was just a horrible decision. She started in the adult system. She had to prove that she had a right to go back, right? So I'd like it to be, and my colleagues around the country now are working, it's not the kid who has to prove that. The prosecution should be proving that the kid can't be rehabilitated and before sending someone to the adult system, which is hardly, and Britain, by the way, was one of the first of those. The James Bulger case some years ago involved a 10-year-old killing boys 2 and 4. And there was also the case of a girl named Mary Bell in England, who was 14 when she committed a crime against a 4-year-old. And a woman named Gita Serini wrote a book about that because Mary Bell was thought to be a bad seed. And it turned out that her mother had taken her with, she had been abused, involved in prostitution, sexually abused. It wasn't a bad seed. She was badly abused. And that didn't come out until many years later when Gita Serini wrote the book about her. So burden of proof should matter. I'm sorry, I ramble long on that, Professor Cary, but it's one that I've cared about. My very, very first cases at Juvenile Law Center involved this issue of transfer to juvenile court. And in 1975, I could win those cases because the prosecution had the burden of proof. And I could also put on evidence that would be helpful. The automatic transfer eliminated that.
This is fascinating. I want to just bring up one more thing. I don't, if nobody else has other questions, which is something you said, 2 things. One thing was that you said, I lost many cases, and you were going on to say, under these circumstances. I wanted to emphasize that. There's a way that we tell triumph narratives now that eliminates the amount of failure that one often encounters working toward a goal. And the other is, you said just one strategy never works. And then you just lined up all of these strategies. And I think that those 2 facts are connected.
Yes, they do.
Yeah, they go hand in hand. Just for a minute, talk a little bit, because I think one of the reasons that I love to teach a class that's academically based community service and that talks with real people making real change in the world and how we tell their stories. One of the reasons I love this is because we learn things you need to know in order to go out of here and be successful, besides just doing well and getting A's and everything will be fine.
Yeah, so let me do a corollary to the failure and football analogies. Because I've said this many times, and recently when I was on a panel in Washington this past December, and because I do talk about failure a lot. We've had many successes at Juvenile Law Center. We wouldn't be around for this many years without changing the world in substantial and important ways. But we got to the point where I could talk to my funders about failure and still get their investment in us because they knew that we would use it wisely. But what I said at this conference was making an analogy to Philadelphia sports talk radio, where the callers call in and say, well, all the Eagles had to do was throw the ball here, or why didn't they run the ball there? It's as though there wasn't another team playing against them, right? I mean, it's in the world of social justice, there's another team out there that is well-funded and formidable, that is doing everything to undermine what you're doing. So you have to take that into account. the strategies that I would often lay out. I mean, and I lost cases in part because I got to know my clients and I knew they weren't the people being described by prosecutors. So I never, in my salad days, I didn't take as seriously as I should have the way the prosecutors and judges would view the kids I represented, right? Because they weren't the kids I knew. There's another side out there, and it's whether it's the prosecutors, a little less so now in Philadelphia with the current regime, but historically and generally to be true in state legislatures, in Congress. Now, a little bit has changed when Republicans began being arrested in the 80s for committing crimes and going to jail. And people like the Koch brothers and others began funding criminal justice reform efforts because to many conservatives now, the criminal justice system is a government system that doesn't work. It's just one more example of that, which we want to leverage and play with. So you want to get non-traditional allies depending on your issue. You want to get champions. And ironically, and frankly, I'll use just another example. Another movie you could watch on Netflix is Kids for Cash, about we were involved in a case that began in 2007 when we discovered that, well, actually over the next couple of years, that two judges in Luzerne County, Pennsylvania, Wilkes-Barre, had taken about $3 million in bribes to keep kids locked up in a detention center that was run by a for-profit manager. As you'll see in the movie, the kids involved in that old coal country where the primary industry shifted from coal to corruption, the kids were largely white. The legislature in Pennsylvania is largely white and responded to that. We took advantage of it and we ended the shackling of kids. We got kids deemed to be indigent and requiring appointment of lawyers no matter what their parents earned, and many other changes, riding that wave of white people being appalled by bad practices to benefit everyone, including Black and brown kids in Philadelphia, Allegheny County, Dauphin County, in Pennsylvania. So you take advantage of opportunities where they come. And you recognize that there's another team, and you recognize that failure is just a step along the way that you have to learn from. It's hospital, and City of Philadelphia has a child fatality review team. What went wrong in our ability to protect these infants? You have to have safe places to examine your failures. And you also have to avoid finger pointing with your colleagues because we're all in this together. So failure is a big deal and always is. And I actually love talking much more about our failures than our successes because those to me have been in many ways more instructive. But I don't know, did I answer the question? I started not where I began, let alone
Yes.
let alone where I ended. So.
Yes, you absolutely answered the question. Thank you. Thank you very much. Thank you, Bob Schwartz.
Okay, thank you all in the class, and I really wish you the very best. You're embarking on a really exciting time in your lives. I look back and really there's no better time to be doing what you're doing. So thank you very, very much for having me, and good luck, and God bless you in your endeavors. So,
Thank you. Thank you, Bob, so much.
Bye-bye now.
Take care. Bye-bye.